tremendous response to this call and a great interest, and we're very grateful for your participation. However, we will limit the questions and answers to members of the media only. So please hold your questions if you're an advocate or a member of the community for later, when we will have other calls open to that discussion. So on today's call, we have the authors of an amicus brief that opposed the case that Texas and 25 other states had brought against the president's executive action. To the call, we'll hear from Marielena Hincapié, who's the executive director of the National Immigration Law Center, Melissa Crow, the legal director at the American Immigration Council, and Debbie Smith, associate general counsel at SEIU. They will give short presentations, and then they will be happy to answer press calls. So, Marielena, please take it away.
Great. Thank you, Wendy, and thanks everybody for joining us today. As Wendy just mentioned, my name is Marielena Hincapié. I'm the Executive Director of the National Immigration Law Center, an organization that defends and advances the rights of low-income immigrants and their families. We're really thankful that you've joined. With me today, we have Melissa Crow, Legal Director of the American Immigration Council, and Debbie Smith, the Associate General Counsel of the Service Employees International Union. On December 29th, our three organizations filed in what's called a Friend of the Court brief, along with the American Immigration Lawyers Association, Fine Americans, the National Immigration Justice Center, the New Orleans Work Center for Racial Justice, Southern Poverty Law Center, and the United We Dream Network. We're each going to provide a few remarks, and I will also make some remarks in Spanish, but we want to save most of the time for questions from all of you. So to begin with, last night, just shortly after midnight Eastern Time, Federal District Judge Hanen issued his decision temporarily blocking two of the immigration initiatives that President Obama announced on November 20th. These initiatives, once implemented, will allow 4 to 5 million immigrants who meet certain requirements to come forward and apply for the opportunity to work here in the United States lawfully and to live free from their fear of deportation. It's important for everyone on the phone today to know that yesterday's decision is only temporary. The Department of Justice has already indicated that it would appeal the decision to the Fifth Circuit Court of Appeals, and we urge them to seek an emergency stay and to do so as swiftly as possible. Immigrants, their families, and our communities should not despair or be afraid. In fact, that is part of the intention behind this political lawsuit. The intention is to create confusion and fear in our communities. It is critical that eligible immigrants continue preparing their paperwork and get ready to apply for either the expansion of the Deferred Action for Childhood Arrivals Program or the Deferred Action for Parents of Americans and Lawful Permanent Residents. We are confident, as are the majority of legal scholars across the country, that this temporary injunction will be eventually lifted, and our communities need to be ready to benefit from this. In a narrow, but lengthy 123-page decision, as you can imagine, we are all still now reading and analyzing the decision, but are here to share some of the initial thoughts. The federal court in Counsel, Texas, has, with this decision, put the lives and livelihoods of millions of immigrant families temporarily on hold. For immigrants who came to the U.S. as children who've been waiting for years to apply for the expansion of DACA starting tomorrow, today's decision represents an unnecessary delay in allowing them to come forward to contribute even more to the only country that they call home. It's important to note that this decision does not affect the original Deferred Action for Childhood Arrivals Program announced by the administration back in June of 2012, nor does it affect the renewal of people who already have DACA. It also does not affect the president's other policy announcements made on November 20th, such as the different priorities for immigration enforcement in the interior and at the border. These policies were not at issue before the court, and immigrants who are eligible for DACA, again, under the 2012 announcement, should continue to come forward and apply, whether it's the first time or for their renewal. Finally, today's decision could have a huge impact on all Americans if it's not swiftly stopped. Immigrants and their families are not the only ones who will be affected by a delayed implementation of these initiatives. Immigrant-rich states like California and New York law enforcement leaders from across the country, and major city mayors all have explained that these initiatives will actually allow immigrants to come forward, pass a background check, and receive work authorization. And this is all good for public safety, it's good for our economy, and it is sound public policy. We in the community will not be deterred. We will not be stopped. Immigrant communities, along with our allies in every sector and in every state of the country, are going to continue fighting to make sure that our communities who won this victory will be able to actually benefit from this victory. We'll continue to work in the halls of Congress, in our communities, in the streets, and in the courtroom to ensure that millions of aspiring Americans waiting for the opportunity to be fully integrated into our country, to contribute more fully to their families and to their communities, will be able to do so. Our next speaker is Melissa Crow, and then Debbie Smith, and then I'll close with some Spanish comments and open it up for questions. Melissa? Melissa, you're on mute. We can't hear you.
Hello?
Great. We can hear you now.
Thanks, Marielena. I'm going to speak briefly about what the decision says and the rationale behind it, and I'm happy to get more into the weeds during the question and answer period. So the first main point is that the judge found that Texas, at a minimum, has standing to bring this case. And standing, as most of you probably know, is the authority to file a case based on the likelihood of harm. The judge found that Texas was likely to suffer a significant economic harm as a result of the added expense that it would incur for issuing driver's licenses to those who were granted expanded DACA and DAPA under the new initiatives. And it's kind of interesting that this narrow consequence was really the main basis for his finding, and in our opinion reflects cherry picking of evidence by the judge. There was so much more evidence in the record, including but not limited to evidence in the brief filed by amici on the phone and more broadly about the considerable economic benefits that states would derive from the initiatives. And of course, there were a number of other amicus briefs filed by Washington State and others confirming that there would be a positive economic impact as a result of these initiatives. So Judge Hanen first found that Texas had standing, and then he found that the U.S. government had failed to comply with a very technical provision of the Administrative Procedure Act, which requires that a proposed rule be posted for notice and comment before it's issued. Interestingly, in the course of his very long decision, which we just finished reading, he actually affirmed the authority of the Secretary of Homeland Security to dictate the agency's enforcement priorities and to marshal its resources accordingly. But he found that the government had failed to comply with this very technical requirement. Now, the technical requirement only applies if the proposed initiative actually constitutes a rule. And in most cases where we're dealing with enforcement issues, as we are here, courts have found that the Administrative Procedure Act forbids the review of acts that are, quote, committed to the discretioncy of the agency under law. And for literally decades, courts have declined to review the type of initiatives that are at issue in this case. So we continue to believe that the president and the agency are well within the bounds of their authority in their issuance of the directives that we're talking about here. And I think I'll stop there and leave the rest for questions.
Great. Thanks, Melissa. Debbie? Debbie, you may also be on mute. Yeah, we can hear you at the moment.
Hello, hi, this is Debbie, and I'm here as one of the amici on the Texas case. SEIU, the Service Employees International Union, has a long history of supporting immigration reform, and we see the deferred action implementation of the President's immigration action as one of the steps on the road to immigration reform. And the judge's opinion today, his extremist opinion, really couches itself in legalese, but it's an attack on, as Melissa said, the long-standing authority to decide how law enforcement should enforce the law. And he says he doesn't care that for 50 years every president has exercised prosecutorial discretion in the realm of immigration. He believes that it should be overturned. So our message to our members and to families who are preparing for deferred action, whether it's expanded DAPA or DAPA, is don't panic. Keep preparing. Keep gathering documentation. We think that this is a timeout, a bump in the road in the fight towards comprehensive immigration reform. It's not the end of the game, and we think that justice will prevail. And we do think that the suspension is temporary. It's not the end, and that we have to keep continuing to hold DACA and DAPA outreach forums to the community. We need to continue preparing for DAPA and DACA. We need to continue collecting documents and stay tuned in to see how this case proceeds. This is the beginning of a fight.
Great. Thank you, Debbie. So I'll just make a couple of comments in Spanish and then open it up for question and answer. So muchas gracias de nuevo a todos ustedes por unirse con nosotros en esta llamada. Vamos a tomar preguntas solamente de los medios de comunicación porque tenemos a casi 200 años en esta línea. Es importante que todos reconozcan que a pesar de la decisión del juez federal, Judge Hanen, de Toronto, Texas, anoche, su decisión, el fallo es de 123 páginas y sin embargo, aunque parezca que es una decisión muy seria, sin embargo, el juez ha decidido ignorar por completo décadas de precedente legal y jurídico, donde la mayoría de todos los expertos legales de leyes constitucionales y de inmigración estamos todos de acuerdo que la administración Obama actuó con toda su autoridad legal y ejecutiva que está muy establecida tanto en la Constitución como en los reglamentos y en los estatutos. Es importante que la comunidad entienda en particular que esta decisión solamente afecta las nuevas iniciativas que fueron anunciadas el 20 de noviembre, que incluyen la expansión de acción diferida para los jóvenes, personas que vinieron antes de los 16 años, y que ese programa las personas iban a poder empezar a aplicar o a solicitar a partir de mañana. Esa iniciativa queda bloqueada temporalmente. También la acción diferida para los padres de niños estadounidenses o residentes permanentes también queda bloqueado en la implementación temporalmente. Estamos convencidos que cuando el Departamento de Justicia apele esta decisión a la Corte de Apelaciones va a ser expresada eventualmente por la autoridad también establecida. Le urgimos, sin embargo, a la administración que el Departamento de Justicia debe exigir pedirle a la Corte de Apelaciones que reverse esta decisión para que puedan seguir adelante con la implementación de estos programas. También es importante que la comunidad entienda que esta decisión no impacta para nada las personas que tienen acción diferida bajo el programa del 2012. Tampoco afecta, por ejemplo, los cambios sobre las prioridades de quién es considerada una prioridad para la deportación. Cualquiera de los demás anuncios que formaron parte de la acción ejecutiva el 20 de noviembre no ha sido afectada por esta decisión. Es importantísimo que la comunidad siga organizándose, preparando todos los documentos, ahorrando el dinero para que estén completamente listos. El día que esta decisión sea reversada, que puede ser cuestión de semanas o meses, estemos todos listos para archivar esas aplicaciones para que la comunidad se pueda beneficiar de esta victoria que nosotros mismos nos ganamos. Con eso vamos a abrir las líneas para preguntas de los medios de comunicación solamente. Van a haber otras llamadas para los miembros de nuestra comunidad. Wendy, can we open it up for Q&A now?
Absolutely. Okay, so all the lines are muted, so if you want to ask a question, and remember, we're limiting questions to members of the media. So if you represent a media outlet and you'd like to unmute your phone and ask a question, please press the star and 6, and then your line should open and we should be able to hear you.
Hi, this is Victor Ramos from Newsday, New York. I have a couple of questions. I was wondering if you can spell out a little bit more what's the roadmap ahead for appealing the decision, and how long do you think that process will take? Is it something that will delay implementation for months, for weeks, or would it be longer than that?
Sure. Melissa, do you want to start now?
Sure. We hope that the government will very quickly file a motion to stay the preliminary injunction that the judge granted. Can you hear me? Hello?
Yeah.
Go ahead.
Yes.
Okay, sorry. Yes, we hope the government will move immediately to stay the injunction that the judge granted. And normally, the Fifth Circuit Court of Appeals would rule within a few weeks. We hope it will be sooner. If the stay were granted, then the program could go forward as planned as soon as the stay was in place, and then the merits of the appeal would be heard within the next several months, but the program would already be underway. If the stay is not granted, then the program may be delayed for a bit longer. But we're confident that Judge Hanen's decision will ultimately be overturned based on the law.
Hello, this is Mariela Salgado. I was wondering if there's a precedent when we talk about the next stage of legislation, this emergency appeal Fifth Court. Do we know in the past how they ruled? Is there a positive that there's going to be an outcome that will reverse the judge's ruling or opinion or temporary freeze?
Sure. If everyone could identify their media outlet, too, when they ask their question, that would be helpful.
Okay, right. And you said you were with Univision, right?
Yes, I'm with Univision, with Noticias from New York.
Great.
It's kind of a follow-up to the question that the other reporter just asked after the next step of litigation, basically whether there's a precedent on that Fifth Court, whether they've ruled before on immigration. Do we know what might be the outcome? Do we know the judges?
Sure. So this is Marielena Hincapié from New York. I'll give you a couple of examples on that. So one, this procedure, what's called an emergency request for a stay, is very common, right? That happens in all types of cases in all courts of appeals at all levels. A couple of examples that I would give is you might remember HB 56, which is Alabama state anti-immigrant law, which our organization sued along with many other immigrant rights and civil rights organizations. We went through a very similar process in that the district court, you might remember, initially ruled against it and allowed most of that of HB 56 to go into effect. It was actually the opposite. We were trying to block it from going into effect, and the state wanted to be able to implement HB 56. And we saw, and the Department of Justice was part of that lawsuit as well. They had their own separate lawsuit. We were able to reverse through that emergency stay. So that's very common. In the Fifth Circuit, which is the circuit that covers this lawsuit, because it was filed in Brownsville, Texas, the Farmers Branch case, which also is a lawsuit against an anti-immigrant legislation was, or ordinance was also blocked and went through similar proceedings. So we are confident that there is both ample legal precedent as well as procedurally. This is something that is done regularly, and because there is such widespread of agreement among legal scholars, constitutional and immigration law scholars, that the Obama administration acted within the legal and executive authority that they have, will be reversed.
Thank you. I don't know if I can ask another question or if you want to give somebody else a chance, but I was a little bit puzzled about the whole thing. The states are claiming, as I believe, that the defense will impose a big charge or expenses on their part in public schools and getting their driver license, and that the government basically could not impose that on them. However, as I think I know, the Constitution says that you are supposed to have public schooling, who you are and your undocumented status. Yet when you read of the judge, it seems like he's not even referring to the constitutionality, really making it about procedural protocols and administrative laws. I'm a little bit lost as to whether this has to do with constitutionality or not.
Well, I think you've answered your own question. I mean, seriously, I think that's a perfect example of the fact that the judge pretty much ignores the Supreme Court decision of Filer, which says, as you noted, that all children are eligible regardless of status to go through public education from K through 12, but that wasn't really given the weight that it carries. I don't know, Melissa or Debbie, do you guys want to add anything else on some of the other points you made?
Sure. I was just going to... Oh, go ahead. Go ahead, Debbie.
Oh, I'm sorry. So I was just going to say the exact same thing, which is that it appears that the judge wants to relitigate the Filer decision from 1982, a Supreme Court decision that allows all children in the United States to receive the benefit of public education. And he goes on to say that it costs the state of Texas $9,400 a year to educate undocumented children. Well, that's not an issue in this case, and that sort of reflects the kind of approach that this judge is taking in reviewing the case. And so I think it's more contextual than actual a decision that the judge is making in the case, but it gives us an idea of where he's coming from.
And I was just going to add that the judge also, as I alluded to before, overlooks the substantial evidence of the positive economic impact on states, which we discuss at great length in our brief, ranging from an increase in wages to more tax revenue to creating new jobs, and the tremendous social benefits of having the beneficiaries of these initiatives in our communities. All of these points are reiterated in the brief filed by the state of Washington and 12 others, which emphasizes that there is no legal or factual support provided in the plaintiff's brief that there would be increased spending for public safety or health care, or, of course, that the new initiatives would foster an influx of undocumented immigrants.
Hi, this is Patricia from Tu Punto de Partida in Boston. Can you hear me?
Yes.
Thanks for taking my call. I just want to ask two quick questions. Number one is, are we going to be so false hope by telling them that this is just a bump in the road, keep preparing, but as you said earlier, this may take months to get a reverse positive decision?
So I think that's a very good question. Go ahead, Debbie.
Yeah, no, I was just going to say that the DAPA program itself, the DAPA initiative and deferred action, does not contemplate beginning until approximately May 19th. So in terms of the importance of continuing the momentum, of having people continue to prepare, for outreach continue to go on, we think it's really important to prepare for that eventuality that we will win this case, and we feel very confident about that.
And Patricia, this is Marielena. I think your real question is very, very important, and I'm sure many people in our community will have the same question. That is, if you look at what the judge's decision actually is, again, he recognized that the administration has full discretion to decide which priorities. He decided to focus on a procedural issue that they didn't go through a proper rulemaking. And once they do that, you are no longer muted and get reversed. The administration could take that approach, which is to go through the proper rulemaking, get public comment, and then issue the rule, and then we would be fine, hypothetically. So I think from a political perspective, it's extremely important for the community to understand that from a legal perspective, this is on solid legal footing. And actually, that the larger the numbers of people that come forward to apply, the more likely we can protect both the expansion of DACA and the DAPA program.
And just a follow-up question, what's going to happen with the people that perhaps are in deportation proceedings, DACA people, and now they find themselves with having to not have this window of opportunity?
That are eligible for existing DACA or 2012 DACA or the new DACA?
The new DACA.
Go ahead, Melissa.
I was just going to note that in addition to the initiatives that are the main focus of this decision, the Secretary of Homeland Security on November 20th promulgated new enforcement priorities for the agency that really clearly specify the categories of non-citizens that the agency is going to target in its enforcement efforts. And to the extent that people in removal proceedings don't fall into these categories, which are focused on threats to public safety and national security and border security and so forth, the removal proceedings should not proceed anyway. And one enterprise that we're going to spend a lot of time and resources on in the coming weeks and months will be to educate lawyers and the community about how to request prosecutorial discretion proactively, particularly for those individuals in removal proceedings. But our hope is that DHS will also decline to pursue proceedings in those situations and just either take the cases off the docket temporarily or perhaps more permanently by terminating them.
Hi, this is Maria Leon, reporter with Spanish News Services. Can you hear me?
Yes, Maria, go ahead.
My question is, how significant it could be that 26 states, more than half of the country, are fighting against this executive order?
It's a great question. Debbie, do you want to respond?
Yeah, I think it's really interesting to look at the states. They are primarily represented by Republican governors and attorney generals. The number of 12 states and the District of Columbia, some of those states are the most populous states in the country, including California, New York, etc., took the absolutely opposite point of view, and as we've been saying, pointed to the benefits of bringing people out of the shadows, how it enhances our economy, how it enhances law enforcement. And so, I think probably if we count up the population, I know that the National Immigration Law Center has looked at some of this, you'll find that in terms of actual population involved, that 26 states, again, Republican-led states principally, are in the minority when you look at public opinion and even population.
And Lydia, this is Marielena, and I would add that to me, I think one of the most significant about those 26 states, as Debbie mentioned, not only is it that they are by Republican attorney generals or governors, but if you look at which states those are the same, many of them are the same states that have passed anti-immigrant legislation at the state level. Also, some of the same states that have anti-worker, anti-women's choice legislation, and they really represent a part of our nation that has focused on the politics of fear rather than really integrating our communities. And so I think that is probably the most significant thing. On the other hand, the states with the largest immigrant populations and cities with immigrant populations and a history and rich experience in working and living with side-by-side immigrants have taken the opposite approach, which is to support the executive action. So I think that is probably the most significant thing. It's it shows us what those states are afraid of the changing demographics of this country.
Hi, this is Lori from Telemundo Network here in D.C. Good morning to all.
Hi, Lori.
Hi. Couple of questions. On a scale of 1 to 10, 10 being the highest,
You're welcome. Come anytime.
what is the probability that this case could reach the Supreme Court, number one? And number two, I imagine you guys have been in contact with the Justice Department or DHS, will they make some kind of formal announcement as to if they are, letting people know they're not going to begin accepting applications tomorrow, Wednesday? And the reason I ask if they are going to make that announcement is because so much work has been done trying to warn our community not to fall into the hands of people who are going to be trying to maybe take their money. Lo que le llamamos los estafadores, los timadores.
Exacto.
So are you expecting an announcement from be it USCIS, be it DHS, somebody saying, while we appeal, we are not going to take applications as of tomorrow? What are you hearing from them?
Yeah, so that is definitely the expectation that the administration will be putting something out in writing. In fact, I know Director Rodriguez was doing some press today that was pre-planned, and so I'm sure as part of that press work, we'll be speaking to this issue as well. And we all have to do that work collectively, Yori, right, with getting the message out to the community. And that's why all of you joining this call is so important to get that message out to the community so they're not exploited by people who are trying to take advantage of them. Do you want to take the Supreme Court part of the question?
Sure. I was just going to add that it's also possible that USCIS will announce that it will accept filings starting tomorrow, and it will just hold them pending resolution of the lawsuit. And that would enable the community to keep making progress in helping people to collect their documents and put together their applications, and it would enable the agency to hit the ground running when the program does go into effect. So that's one other possibility. I think that whoever loses before the Fifth Circuit will request Supreme Court review. I think it's anyone's guess whether the Supreme Court will grant that request. But we expect that it will happen relatively quickly after the Fifth Circuit issues a decision, either on the stay, initially on the stay, and then later on the merits of the preliminary injunction.
This is Debbie, and I just wanted to follow up on the kind of information that we anticipate will be coming out of USCIS. And I guess I would look to the CIS website, which has been the source of the FAQs on DACA, to provide some information about that. So far, the new DACA form has not been posted. What was posted were the FAQs and a draft instruction on expanded DACA. So I would think we want to look to the CIS website, and I definitely agree with you that it's so important that people be aware of what they can do and not be exploited by notaries.
Marielena es la nieta de esta hija. Oye, quería preguntar rápidamente en español si me podías repetir, por favor, cuando estabas hablando del precedente que existe en la Corte del Quinto Circuito, si me podías repetir el precedente específico que nombraste, el caso específico. Yo estaba revisando todos los jueces que integran la Corte y la verdad parece difícil, cuando sobre todo parece difícil una decisión que tenga que ver con inmigración, de un estado donde este debate es muy político y es muy diario. Entonces quería ver si me podías repetir el precedente, si me podías comentar o elaborar un poquito más sobre qué va a pasar en la Corte del Quinto Circuito. Claro, bueno, yo creo que la primera cosa concreta que diría es de que este tema, como acabas de decir, es muy político por ser el asunto de inmigración, pero el asunto legal, el asunto constitucional ante la Corte, en realidad no es un tema ni liberal ni conservador. En realidad, cualquier juez que esté siguiendo la ley al pie de la letra debería de haber fallado a favor de la administración Obama y encontrado que la acción ejecutiva fue
constitucional y que el programa podía ser implementado sin ningún problema. El quinto circuito, la Corte de Apelaciones es considerada una Corte de Apelaciones más bien conservadora, pero uno de los casos principales con respecto al asunto de inmigración que fue decidido el año pasado fue el caso de Farmers Branch, que tenía que ver con una de las medidas anti-inmigrantes fue debatida acerca de qué derechos tienen las personas indocumentadas en ese estado. Te podemos enviar la decisión para que la tengas presente. Y no solamente este caso, pero también hay casos que no han llegado a la Corte de Apelaciones por el tema de migración, que han favorecido a los inmigrantes, que han protegido los derechos del debido proceso. Por ejemplo, también hay uno que es ante la Corte Suprema en esta sesión, que fue un caso positivo también de la Corte de Apelaciones en el quinto circuito. Entonces, nosotros no nos preocupa el hecho de que esté ante el quinto circuito. La verdad es que esta decisión de este juez en particular más bien se esperaba, y a veces tenemos mucha conciencia de que en la Corte de Apelaciones esta decisión va a ser reversada, y es por eso que decimos que esto es una medida temporal y que la comunidad tiene que seguir preparándose para que estén listos para someter sus aplicaciones cuando esté reversada la decisión.
When you explained the reasoning, I clearly understood the first aspect of it, the state has to pay. Can you go a little bit more into the other issue of the administrative process that was not followed and what is the precedent there? And then following up on that, the question of, sounds to me like this is an all or nothing deal. In other words, either it gets implemented in all the states or it doesn't. Or is there a chance that the states that are opposing this could resist it all the way through, and then others will allow their immigrants to go through the application and the process?
Do you want to start with
Sure. I think I'm going to start with your second question first. I think you raised a really good point about whether the judge even had authority to grant a nationwide injunction, because, of course, the plaintiffs were 26 states. So it'll be interesting to see how that plays out. We would certainly argue that he didn't have that authority and that he overstretched in a whole variety of ways. In terms of his holding that the U.S. government didn't follow the proper procedures in promulgating these initiatives, the Administrative Procedure Act sets forth very specific procedures about how you promulgate a new rule. And I guess the key issue here is whether the DAPA and expanded DACA initiatives are actually a rule. If an initiative falls within the discretion of the government, in other words, the government has a lot of latitude and flexibility as to whether they are going to do something, then that initiative is not subject to the procedures set forth in the Administrative Procedure Act, which we call the APA for short. One big issue that has been the subject of the briefing and the arguments, and not surprisingly the judge's decision, is whether DACA, or expanded DACA rather, and DAPA do afford the decision makers enough discretion to evade the constraints imposed by the APA. And our position, which is the same as the government's position, is that these initiatives really epitomize the exercise of discretion by an enforcement agency. Merely by promulgating the criteria that render an individual eligible for DAPA or expanded DACA, the government was exercising its discretion to enforce the law. And then once adjudications begin, the decision makers who are reviewing each application and evaluating them will not only determine whether the applicant applicants fill the eligibility criteria, they will also determine whether they warrant a favorable exercise of the government's discretion. In our amicus brief, we actually included a link to the form that was used in adjudicating the original DACA applications, and there is a checkbox on that form that provides that a DACA application can be denied because the person does not, in fact, warrant a favorable exercise of discretion. So I think it's very clear that the initiatives at issue here are exempt from the sorts of procedures that the judge found to apply because they don't constitute a rule under the APA. Does that make more sense?
Yeah, thank you.
Good.
Thank you, Victor. Can we open up for other reporters to ask questions? Hi, this is Serena Marshall with ABC. Can you hear me?
Yes.
Hi, yes, I was just wondering, I know you said the judge cherry-picked financial impact. Can you outline the financial costs for issuing driver's license versus the financial benefit of doing so?
Sure. This is Marielena. I can get started and others can chime in. I think the first benefit I would say is really from a public safety perspective. And public safety and law enforcement agents across the country believe that we all benefit both from a public safety perspective as well as from an economic perspective when all drivers, regardless of their immigration status, are trained and tested and insured. So just from the driver's licensing, which is Arizona, for example, where the judge actually also cited the Arizona Green Act Code that were co-counsel on. In Arizona, individuals with deferred action for childhood arrivals with DACA, they get driver's licenses and pay for those every 3 years, unlike other Arizonans who are issued a driver's license for decades. I believe it's 50 years. People with DACA are actually paying into Arizona every 3 years in order to get driver's licenses. On top of that, there's the insurance costs. The fact that people have the mobility of travel increases their likelihood that they will, be able to go and vacation and spend money and benefit and contribute to the economy as a whole. So the costs really are very much outweighed by the benefits, both economic and from a societal perspective. Anyone else want to comment on that?
This is Debbie, and I just wanted to say that some of the states would contest the notion that it's not that it doesn't pay for itself, that the whole driver's license procedure and protocols that are followed in different states are not self-generating economic ways of paying for driver's licenses, and that there is no additional cost to states for the creation of driver's licenses. So I think that the judge accepted a declaration that was filed by an official in the state of Texas without looking at any other kinds of evidence, and I made a decision based on that.
Okay, let's take the next question.
Hi, this is Tim.
This is Josh Gerstein at Politico. Can I follow up on one of the questions just a minute ago? You were talking about the issue of administrative discretion and whether this falls under that. The judge looked at that list that you talked about with the boxes and so forth and said that it appeared that the administration, at least with respect to the existing DACA program, had never exercised discretion to deny anyone DACA benefits or refused to answer the question of whether they had. How do you respond to his claim that the discretion here is just a pretext and in fact it is just a rote application of the guidelines?
I think the clearest answer to that is based on the experiences of numerous individuals who have approached our organizations for help. We know of a number of cases where individuals were denied DACA solely in the exercise of discretion.
The government wouldn't provide those statistics, and can you just tell me your name because it's hard to follow who's speaking here?
Sure, it's Melissa Crow from the American Immigration Council. If I'm not mistaken, and I need to go back and dig in the government's reply brief, but they did provide much more specific information in their reply brief than they did in their original brief, and I'm happy to dig that up for you.
Hey Josh, this is Marielena from Mills. The only thing I would add to that is one of the things that the states have argued, and they're pointing to the fact that the success rate is so high and that shows that it's a rubber stamp program and that there isn't discretion. I think that we completely disagree with that and reject that. I think the reason the success rate is so high is because so many young immigrants have worked really hard to put their applications together and have gotten service of legal services and other service providers that have worked really hard to make sure that the program was a success and the application process was a success. Now, as Alyssa said, we can point to numerous cases where the administration did reject individuals that we believe were eligible for DAPA, and that was based on an exercise of discretion. We disagree with the administration. We believe they shouldn't have rejected those particular cases. But again, this is our experience, and we at the National Immigration Law Center have been very involved in the implementation of DAPA since 2012, along with United We Dream Network. And our experience is that this is very much an individualized case-by-case adjudication from USCIS, and it takes a lot of work for every individual to put their package of evidence together documenting that they meet all of the criteria.
Right. I would just add that another reason for the low rates is that people who were worried about any problems with their cases were much less likely to come forward than those very strong cases. So it's perfectly understandable that the denial rate would be relatively low.
Right. People self-select. Mm-hmm. Next question. I think we have time for a few more.
If I can clarify something as far as the ruling or temporary freeze from the judge, this is Mariela from Univision again, Mariela Salgado. Is that, it's not a final ruling, as I understand that it's a temporary freeze, meaning that if the federal government did not appeal, then what would be his next steps?
So this is Mariela, and others can continue. So I think your question is a good one in the sense that hypothetically that's true. If the federal government did not appeal, then the program would be basically enjoined because there is this temporary injunction. However, the administration has already, in their own press release, noted that the Department of Justice has indicated that they would appeal. And as immigrant rights advocates, we are urging the administration not only to appeal, the Department of Justice should appeal and also seek an emergency stay so that the implementation can actually go forward.
And when you talk about prosecutorial discretion, trying to train more attorneys, and the reason why I asked you that is because we've done a lot of stories with Niños de la Frontera, children, and we've seen that many cases apply for some juvenile special status. Were you referring to that? What were you referring to, trying to reach and train them on prosecutorial discretion?
Sure. Let's you raise that. Do you want to talk about that again?
I'm sorry, there were a lot of beats. Could you just repeat the question?
Sure. The question is, you had mentioned, I'm sorry, Mariela, go ahead.
No, you go ahead. You probably will be faster than me, so go ahead.
Earlier, Melissa, you were talking about the fact that since the enforcement priorities are still in place, that there's a need to train attorneys to make sure, and other advocates to make sure that the administration is following its prosecutorial discretion and new guidelines and priorities. And you can add more on that.
Sure. So, as I said, in addition to the DAPA and expanded DACA initiatives that were promulgated on November 20th, there was a separate memo that came from Secretary Johnson setting forth very clear enforcement priorities for DHS. And regardless of whether DAPA or expanded DACA go into effect sooner or later, those enforcement priorities are still very much in play, and DHS has stated that it will focus on the highest priority individuals, those who threaten national security, public safety, and the like. So anyone who is in removal proceedings right now should be able to, who doesn't fall into the enforcement priorities, of course, should be able to ask the judge and to ask the attorney from DHS to take the case off the docket. And that's something that can always be done in removal proceedings because the government has openly stated that it doesn't have sufficient resources to enforce the law in every case. So it's to their advantage to take cases off the removal docket so that they can focus on higher priority cases. And that really is what the DAPA and DACA programs are all about. It's an effort to enable the government to focus its resources on the highest priority cases and to take the other ones off the table.
Thank you. Hi, this is Patricia. Just a follow-up. Can you tell us again what should we expect in the next couple of weeks? I think for the average person, they're not going to understand what's going to happen while we wait for this to be appealed. What should we expect in terms of a timeline, if you could give us that?
This is Debbie. I think just to talk about what we think may happen. Again, this is not something that we can give you an exact timeline, but we are hoping that the government will move first at the district court level and then at the Fifth Circuit Court of Appeals to request a stay of the judge's ruling so that immediately ruling will not go into effect. So that's one thing that we hope will happen. At the same time, because it happens consistently at the same time, the federal government will also be appealing the decision on the preliminary injunction to the Fifth Circuit Court of Appeals, and that's where briefing has to take place. And so sometimes those cases can be decided in an expedited way, and they would obviously be requesting a motion to expedite the appeal, so that would also be part of the legal process that would take place, a motion to expedite, so that this can take place very quickly. And in many, many contexts, the Fifth Circuit Court of Appeals has expedited cases.
Great, and Patricia, this is Marielena. The other thing I would add that I think the community should expect, and that would be happening over the next weeks, is the federal government will be issuing notices and guidance clarifying what they are going to do or not be able to do as a result of the decision. And then secondly, many of our organizations and other community-based organizations across the country will be holding clinics and informational sharing. There will continue to be a lot of outreach to communities to understand that the system causes confusion. Hi, sorry to interrupt you, but if you're not on the call, if you're not speaking on the call, can you give your line on the I'll also attempt to mute the lines one more time, and then we'll need to unmute themselves.
But I mean, I'm on.
Great, okay. So, Wendy, if you're muting the line, does that mean that folks will not be able to...
All guests have been muted. You can unmute your line by pressing *6.
Okay, and your speakers, are we unmuted? Yes, I can hear you. Okay, great. So if anybody else from the media has another question, please keep yourself on mute. You are no longer muted.
Hi, this is Tim Painter from 1150 AM Radio in Denver, Colorado. I want to know whether the administration might consider proceeding using administrative, or what do you call it, through the administrative process, rulemaking process. The second thing I want to know is what should people think when, at the one hand, the law is ready to be passed or implemented, and then at the next second, it's withdrawn? Doesn't this cause a lot of fear in people, and what can the media say to maybe quell that fear?
Very good questions. And then Melissa, you guys want to start with whether the administration, do we know anything about the administration going through the rulemaking process? They might be on mute. This is Hanen. I think at this time we have no administration is considering that. However, our understanding with the administration, we and many legal scholars actually did not believe that the expansion of DAPA and DAPA program are subject to rulemaking, and that what the administration did in November was perfectly legal. So I think the more likely scenario is that they will appeal this rather than going through the EPA process, the rulemaking process. But I think that's a question to be reserved for the administration itself, and they might provide some guidance on that in writing. I'm not sure.
Well, I agree with Marielena. Our position is that this is a policy, not a substantive rule, and it is not subject to notice and comment under the APA.
And the last thing I would note is that actually as part of the November 20th announcement, right, this was a package of many different changes that the administration announced on November 20th, which included some making changes. So they are, in fact, going through the Administrative and Procedures Act for certain changes that the Office of Legal Counsel, as part of the Department of Justice, deemed to be changes in the rules. So the administration is very well aware of which, what is a rule change and where they need to go through the APA, and as Melissa said, this we see as simply a directive and a policy change of how to use limited resources. Stephanie, were you trying to jump in?
No, I was just going to say that it's exactly what you were saying, is that the provisional waiver rule, the I-601A rule, is being discussed as being one of the changes that the administration sees will need to go through the notice and comment period. But again, this is prosecutorial discretion, and that is not something that's subject to rulemaking, and that's the position that we're taking. That's the position that the government is taking.
And then I think the second question, I'm sorry, just to answer his last question, because it's extremely important for the community. This is, will the community be confused because from one moment they were expecting the extension of DACA to go into effect tomorrow, and now it's on a hold temporarily? Absolutely, and in fact, I believe that the opponents of the executive action, the opponents of immigrants in this country, have filed this lawsuit with that intention in mind, to confuse the community and to instill fear and chill people from coming forward. They realize that the more people come forward, it'll be a successful program, and it is not in their political interest. So as media, we and community members were asking that everyone help to explain to the community what's happening, to clarify, and our message as advocates to the community is to not be deterred, do not be chilled. It's important to continue preparing and getting ready to actually file your applications if you're eligible.
Well, and Ken, it's better than you'll hear me. Can you clarify? This is Molly with the LA Times. Can you clarify, so are you encouraging people tomorrow to go and file their application for the DACA extension, or I just want to clarify, you're telling people move ahead with your preparations, do what you had planned to do anyway?
I think so. Go ahead, Melissa.
Sorry. I think we have to wait to hear from the government on whether people should actually apply, but the process of pulling together the evidence that will be required to apply is time-consuming and labor-intensive, and people should obviously proceed with that so that they're ready whenever the government gives the go-ahead.
Right, and Molly just did that. I think this is Marielena, just to add, particularly in LA, you will see that there are going to be many clinics being held to help people with that preparation process, help people understand, are they eligible, are they not, what kind of documentation, saving money for the application process. That's what we're referring to when we're saying prepare, don't hold back, don't stay home waiting to hear when this gets reversed. Instead, continue your preparation so that you're ready to apply when the stay is lifted.
I'm sorry, no, the call is 12 o'clock, and then there's another call that's going to take place on the line. You're going to have to end the call, please. On the media alert is contact information for me when you leave. De la Relación and Bill, at SGIU, and we're happy to answer questions. Thanks for joining the call.